What's going on, guys? It is the Bad Wolf, also known as the Man in Black, here to bring you guys some more fire informational pieces, shall we say. And once again, right to travel. You are exactly right. It's like you read my mind. Let's take a look at what we got going on. As always, please be kind to hit that bell, like, and subscribe. Welcome to the Wolf Tribe. All right, guys. Let's check it out. Let's check it out. So by now, if you've heard about Right to Travel, hopefully this is not your first time. If it is, oh man, are you in for a whammer? All right. I would suggest going to my live playlist and looking up the videos on Right to Travel on my main YouTube page. As always, you can find additional information on blacksite32.com. Please be careful about the information you get out there from other people. It may not be, in fact, total. You should learn everything. We've already mastered this. We've won in court countless times. All right. So, but there are proper procedures to do these things. All right. And you're getting them from a great source. So I'm told by thousands of people at this point in time. And of course, I must be doing something right if all the agencies like to watch my video. So hello to all those people out there. I know you guys are trying to learn as well. And here's the thing, nobody knows it all. There are tons of things that are over all of our pay grades that we don't know that somebody else knows out there. That is just the spider web. All right. So if you guys see anybody using my information, likeness, logos, or anything else like that, or me, and calling me out of my name or doing anything jazzy with my materials, make sure that you report them for bullying, slander, and defamation of character, which are all suable offenses. This is just education and entertainment. If you don't like it, go the hell somewhere else. This is for people who are patriots of the United States of America. If that's not you, you shouldn't be here. This is definitely not for anybody operating and living their life who desire to only operate as a U.S. citizen. This is for the state citizen, the national, the non-resident, the private citizen, the private sector. But it's also for the government and the states to know. So I'm glad that you guys watch my videos as well. Or so the people have told me. Hmm. All right. So with that being said, guys, always take care of yourselves, take care of each other, appreciate what you got. If you're going through some things that are trash, let it go. Life is too short and it is already too chaotic to be worrying. If you can control it, then do something about it. If you can't, then let it the hell go. That's it. Don't ruin your life, your mind, and what you have because of past things or whatever else. Move forward, let it go. But that's up to you. All right, without further ado, if you guys do want to donate, blacksite32.com is the place to do it, or you can join the Wolfpack on YouTube, my main channel. And I will thank you because your monthly donation, hold on, let me do it properly. For just a low price of $1.99, upwards to $24.99 a month, you can help somebody like me, which actually would be me, to continue to do what it is I do here. Thank you in advance. And if you're not able to do that, I totally understand. You can send in a one-time donation on blacksite32.com, jameslovett.com, or badwolf.unincorporated.com. Be careful when you're out there doing whatever it is you do out there. And you think it's me in one of these groups or whatever, because there are scammers everywhere. And for the record, try to never think that it's me asking you for money. It'll only be here and it'll always direct you to blacksite32.com. It will never be me just creeping in your DMs or whatever else and asking it for anything money, financial, your records, personal information, stock tips, and whatever else. It's just not me. So put a zero on that. All right. With that being said, now let's jump into it. So this is going to be a longer video. All right. This is not going to be one of my shorter ones. I don't know exactly who to give full credit to this because it seems like it's a compilation of many different people and a lot of efforts and work. So to whoever created the document itself, good job. All right. And with that, we should be, I think it's just about loaded. It's a pretty big document. All right. Make sure it's doing its thingy thing. There we go. Okay, let me blow it up. All right. So this particular document is titled The Right to Travel. It was made back in December of 2009. All right. Now, one name that is mentioned in here is Christopher Tideman. So shot goes out to that particular person and whoever else put in all their materials. I'm going to show you really quick that a number of different agencies. So this isn't just somebody putting together some stuff. Okay. This is, here we go. Let's just get that, and do that. So, because I know law enforcement also likes to watch my stuff, hello to the good law enforcement out there. To the other ones, you can kiss it. Take a look at this. America's jurisprudence. This is the highest law in the land. American law, actual American law, not state, not court, not private. This is the law. The other ones I mentioned, yes, those do, and they are valid if you're operating in that legal jurisdiction. All right. So we've got some internet sources, law dictionaries, black laws, Blackstone. I mean, from driver's licensing law, corpus juris secundum, the Constitution, all these places were used. Look at hoodies, automobile law. I didn't even know that was a thing. Michigan law, state trade, commercial, Department of Transportation, highway safety, Yale. All these places are references for what's going to happen in here. As you see here, table of contents, right to travel. Okay, then we're going to talk about police authority, due process, void for vagueness. They do that on purpose. They make it vague. You cannot have anything vague. If it is, it's not valid. Hell, a majority of these state codes and regulations don't even apply to you nationals. They apply to U.S. citizens. And anywhere where they are, they take away your rights or freedoms, okay, or they try to usurp a constitutional right, they can be ignored with impunity. That comes from the Supreme Court. So then we talk about taxation, statutory history, constitutional character, driving, licensing, traffic infractions, tort liability, public disclosure. So this is going to be a longer video, guys. All right, but this is one of the most comprehensive pieces of right to travel information I've seen. So I'm going to let the lovely AI read through this because I will be winded and tired if I had to read through all of this. Okay, but it's worth it if you're really serious about right to travel. All right. So we're going to go through the definitions. Then once we get through all of these definitions, then we're going to start this whole thing here. This is the complete breakdown. So go get your popcorn, your peanuts, because we nuts and we about to go nuts in this piece. So with that being said, let's go.
Citation. Judicial and Statutory Definitions of Words and Phrases, Volume 8, West Publishing Co., 1905. A citation is a writ of the court, addressed to an officer of the court, and commands him to do certain things. Commerce. From L. Commercium, trade, trafficking.
Now let's pause. A citation is a writ of the court addressed to an officer of the court. So if you're trying to give me a citation, I'm not an officer of the court. You do not have my jurisdiction. The power is in the words, people. I'm not going to go through and analyze because this will be like an 8-hour video. I just want to throw that one out there. That's interesting how this comes from judicial and statutory definitions from West Publishing. So a citation, which is what they give you, is for an officer of the court. So that means a statute. All those things means you are a member of theirs unless you rebut it. I am not. We are not your property. My property, my house, my car, my stuff are not yours. And if you forced me to register my stuff, That's peonage. That's a federal offense. I can do this all day. Let's go.
Trafficking, from calm together plus mercs, gen mercies, merchandise, sea market. From commerce, pertaining to trade, meaning done for the sake of financial profit. Commodity, from
So anywhere where they're doing commerce is for profit, to benefit, taxable. That's the opposite of the private.
commodite benefit, profit, from commoditatum. Constitution. The term constitution when used here in this writing may also be represented by the term charter, and as such, the terms are interchangeable. Constructive contract. A constructive contract is where duty defines it instead of the contract defining the duty to be performed. Constructive contracts are fictions of law adopted to enforce the legal duties by actions of contract where no proper contract exists, express or implied. Graham versus Cummings, 57 Atlanta 943, 208 pascals 616, citing Herzog versus Herzog, 29 pascals, 5 Casey, 465. Convey. Merriam-Webster 9th Collegiate. To transfer or deliver to another, to cause to pass from one place or person to another, transmit. Conveyance. Merriam-Webster 9th Collegiate, B. An instrument by which title to property is conveyed. Driver. Bouvier's Law Dictionary, 1914, page 940. One employed in conducting a coach, carriage, wagon, or other vehicle.
Now, did you hear that it said a driver? So the word driver means one employed, being paid. That's commerce. If you are a driver, have a driver's license, you are being paid, which you're probably not, unless you're CDL or a police officer or such, to be in that car to transport people. This is why the average person does not need a driver's license unless you are doing Uber or something of the sort. I'm not saying not to have one. I'm not saying not to be trained in. I'm just saying if we break down what the word driver means, so whether it's a driver's license, driver's ticket, ticket for driving, were you employed at the time? Were you doing commerce at the time? No, but you got that license. So that binds you to their jurisdiction. Let's go.
Vehicle. Driver. Black's Law Dictionary, 3rd ed. One employed in conducting or operating a coach, carriage, wagon, or other vehicle, with horses, mules, or other animals, or a bicycle, tricycle, or motor car, though not a street railroad car. C. Davis versus Petrinovich, 112 a la 654, 21 so. 344, 36 LRA 615, Isaacs versus Railroad Company, 7 a.m. Republic 418, 47 New York 122. Driver. Black's Law Dictionary, 4th ed., 1951 One employed. License. The law applied to motor vehicles. Babbitt Section 83, at 141 in Webster's Dictionary we find a license defined as authority or liberty given to do or forbear any act, especially a formal permission from the proper authorities to perform certain acts or to carry on a certain business, which without such permission would be illegal. License. Bouvier's 3 RD ed., 1984. In governmental regulation. Authority to do some act or carry on some trade or business, in its nature lawful but prohibited by statute, except with the permission of the civil authority or which would otherwise be unlawful. Operating motor vehicle. Valentina's Law Dictionary, 1969. Exercising control over the vehicle, although not at the time in the driver's seat. Private. Merriam-Webster 9th Collegiate. 1.a, intended for or restricted to the use of a particular person group or class. B. Belonging to or concerning an individual person, company, or interest. private. C.1380, from L, privatus set apart, belonging to oneself, not to the state, used in contrast to publicus, communis, originally pages stem of privari to separate, deprive, from privus one's own, individual, from old L. Pri before. Meaning not open to the public. Privilege. From L, privilegium law applying to one person, from privus individual plus lex law. A right or immunity granted as a peculiar benefit, advantage, or favor. Public road. A roadway existing for the free and unrestricted use of all common people, is a public road. Henninger vs. Peary 47 C 1013, 102 Virginia 896. Register. From L a regesta, neuter pl of regestus, pages of regera to record, literally, to carry back, from re back plus gera carry, bear. Register. Merriam-Webster 9th Collegiate, means enrollment. Register. Black 7th ed. To enter in a public registry. Service. Reverend Code of Washington 63.14.010. Services for which the price charged is required by law to be determined or approved by or to be filed, subject to approval or disapproval, with the United States or any state, or any department, division, agency, officer, or official of either as in the case of transportation services. Traffic. Webster's Unified Dictionary and Encyclopedia International Illustrated Edition, 1960, 1. Business or trade, commerce. 2. Transportation. 3. The movement of vehicles on street or highway. Traffic. Bouvier's Law Dictionary, 1856. Commerce, trade, sale or exchange of merchandise, bills, money and the like. Traffic. Black's Law Dictionary 3rd. Commerce, trade, sale or exchange of merchandise, bills, money, and the like. The passing of goods or commodities from one person to another for an equivalent in goods or money. Traffic. Black's Law Dictionary 6th. Commerce, trade, sale or exchange of merchandise, bills, money, and the like. The passing or exchange of goods or commodities from one person to another for an equivalent in goods and money. The subjects of transportation on a route, as persons or goods, the passing to and fro of persons, animals, vegetables, or vessels, along a route of transportation, as along a street, highway, etc.
So that tells you right there that traffic is their word. I've been telling you guys, these are their words. When you use their words, you're speaking their language, and it means commerce. Com, C-O-M, okay, for common. Merce is for merchandising, merchant. This came from the word merman. Mer, water trade, water business, Atlantean in its origin. They were the first mariners. That's even that is their word. Okay? So you guys get the basic understanding that this is the dictionary section. All right, so let's jump down here.
U.S.C. Title 18 Section 31, 6, Motor Vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the...
Whoa, did you hear that? So the term motor vehicle for the U.S. Code 1831-6 means that any description of something that can carry somebody around, other than probably like a horse, if you call it a motor vehicle, so to be able to call something a motor vehicle, you have to own it. The city doesn't own your car, but they have some leeway into it if you register it. So you registered your name That gave them some jurisdiction over your straw man, which you believe to be you. Then you registered your motor vehicle. All these words are commercial. You're contracting each time. Contract, contract, contract. And then here, once again, it says commercial purposes. That means for profit. And it generally means on or in the public and under their jurisdiction. Do you have the right to do these things without them? Yes, as long as you properly know how to handle your vehicle and obey the rules of the road. But they can regulate a motor vehicle that is registered to them. But you have the ability to be private. We own the roads. We pay for them. They administrate these things if there is a controversy. You were speeding, you did damage, you got to an accident, then they get involved. Other than that, you have the right to be private. So you're telling me you're forcing me that my private conveyance must be called a motor vehicle, must do commercial or have commercial? No, there's no law. What they're saying here is that if you are a U.S. citizen, which would really mean somebody born in the District of Columbia, or a legal person, which generally is your name in all capitalized letters, and then even from there, you then register it to them, yes, you absolutely 100% must abide by all of these rules. Okay, once again, we're just going to kind of jump through. They talk about what a vehicle means, common carrier. The word transport is theirs. Okay. So let's jump into it. You guys ready? Let's go.
Right to travel, freedom of movement, methods and modes of locomotion, use of streets and highways. The constitutional right of individuals, in the exercise of their liberty interests, by claiming their right to travel, in this writing, is a 100-year-old concept, as it relates to the introduction and evolution of the automobile industry, and an individual's necessarily impetuous need to travel the common highways. As indicated herein, the highways were established for the use of the general public. Streets and highways are established and maintained primarily for purposes of travel by the public and incidental uses. Jure 2D Highways, Streets and Bridges Section 227, citing Birmingham Re. Light and Power Company v. Smyer 181 ALA 121, 61 So 354. The term travel is a generic and broad term. The phrase incidental uses in the above citation means the use of the highways as a means of personal gain, discussed later on. It is now, and has been known, that traveling is of two basic categories: those who travel in a personal capacity for pleasure and those who travel the public highways incident thereto for profit. The terms travel and traveler are usually construed in their broad and general sense were used in this connection, rather than in a narrow and restricted one, and the duty and consequent liability is extended so as to include all those who rightfully use the highways viatically, and who have occasion to pass over them for the purpose of business, convenience, or pleasure. Van Cleef v. Chicago, 240 IL 318, 88 NE 815, 23 LRA, NS, 636, 130, AM Street Rep 275. Traveling for pleasure connotes the movement from one place to another for one's own enjoyment, as in the case of visiting friends and relatives. However, it is undisputed that the use of common highways is also for general purposes. Those common purposes may include, but are in no way limited to traveling to or from the following places: doctor, veterinarian, grocer, hardware store, beach picnic, coffee stand, work, movie, funeral, convenience mart, bank, school, families' homes, dinner out, sporting events, etc. A distinction may also be made between private carriers who transport their own property for compensation and those who transport their own property without compensation. The use upon the public highways of motor vehicles engaged in transportation for hire may be prohibited, restricted, or conditioned by the controlling public authority. Highways are public avenues for use by the entire public for their private and personal purposes, and the use of a highway for profit and gain may be restricted. Stevenson v. Binford 287 U.S. 251, 53 SCT 181. Based upon the fundamental ground that the sovereign state has the plenary control of the streets and highways in the exercise of its police power, may absolutely prohibit the use of the streets as a place for the prosecution of a private business for gain. They all recognize the fundamental distinction between the ordinary right of the citizen to use the streets in the usual way and the use of the streets as a place of business or a main instrumentality of business for private gain. The former is a common right, the latter is an extraordinary use. As to the former, the legislative power is confined to regulation; as to the latter, it is plenary and extends even to absolute prohibition. Since the use of the streets by a common carrier in the prosecution of its business as such is not a right but a mere license of privilege. Hadfield v. London, 98 Wash 657, 168 p. 516. The use of the highways for the purpose of transporting persons or property for hire by the ordinary means is incidental to and consistent with the primary purpose of their establishment, highways, and is therefore a proper use in the absence of any restricted regulation. Such use is not, however, one which may be exercised as of right but is a special or permissive use. A street is a road or public way in a city, town, or village. A way over land set apart for public travel in a town or city is a street, no matter by what name it may be called. It is the purpose for which it is laid out and the use made of it that determines its character. As the way is common and free to all people, it is a highway, and it is proper to affirm that all streets are highways, although not all highways are streets. Huddy on Automobiles, Section 26. Remington Reverend Stat, Section 10512. P.C., Section 5639, reads in part as follows. All state and county roads, streets, alleys, avenues, boulevards, parkways, and other public places actually open and in use, or to be opened and used, for travel by the public. Further, a highway is a way open to the public at large, for travel or transportation, without distinction, discrimination, or restriction, except such as is incident to regulations calculated to secure to the general public the largest practical benefit therefrom and enjoyment thereof. Its prime essentials are the right of common enjoyment on the one hand and the duty of public maintenance on the other. It is the right of travel by all the world, and not the exercise of the right, which constitutes a way a public highway, and the actual amount of travel upon it is not material. If it is open to all who desire to use it, it is a public highway, although it may accommodate only a limited portion of the public or even a single family, although it accommodates some individuals more than others. Citing 25 AM. Jure 339, Section 2. Highways are public ways as distinguished from private ways. The distinguishing mark of a highway is that it must be open generally to public use, as expressed in the English books, common to all the king's subjects, although it is the right to travel upon a highway by all the world and not the exercise of the right which makes the way a highway. Its character is not determined by the number of persons who actually use it for passage. If it is open, it is immaterial that but few individuals are in a position to make use of it, or that one person is most benefited by it, and its character as a highway is not affected even by the fact that it furnishes access or egress to but a single property owner. Citing 29 CJS 366, Section 1. State of Washington, in Re Oregon Washington Railroad and Navigation Company et al. V. Walla Walla County et al. 5 WN.2 D95. To further proliferate the fundamental liberty that is the right to travel the common highways is the language below. In the first sentence, in italics, the court uses the language existence, creates, permits, will. These words are proof positive as declared by the courts, that one has a constitutional liberty interest in the free uninhibited use of the public highways. To exemplify these words, they become the epitome of divinity. Existence is existential, creates is creation or creator, permits is permission, will is liberty or freedom. The pinnacle summation of the foregoing, in strict text, reads, existence from creation is existential permission by our Creator to the free use. Remembering that phrase, we understand the dominate introversion of private traveling versus the extroversion of traveling for hire and/or commercial travel. The evolution of the highways dates back centuries, but this writing is confined to the 20th century. The road is what our grandfathers' grandfathers traveled to survey and settle this continent. It was traveled by horse, mule, and wagon. Those people were not required to have a HUD on automobiles. 6th ed. Citing. The use of such new and improved means of locomotion must be deemed to have been contemplated when the highways and streets were laid out or dedicated, whenever it is found that the general benefit requires it, and such new means of locomotion cannot be excluded therefrom or be deemed unlawful merely because their use may tend to the inconvenience or even to the injury of those who continue to use the highways and streets by former methods. One may transport his goods over the highway in wagons, automobiles, or other vehicles, loaded thereon or therein as he may deem best, provided that in so transporting them he uses the care that a prudent man would use, care commensurate with the dangers created by his undertaking. HUD on automobiles. 6th ed. Citing. HUD on automobiles. 6th ed. Section 31. The proviso as to use by the general public, see Birmingham Re. Light and Power Company v. Smyer Supra, by the usual and customary mode of transportation not inconsistent with the current status of mobility, which is a legally and lawfully acceptable use. The state's duties and obligations with respect to the safety of streets and other public ways are limited to keeping them reasonably safe for the uses for which they are intended, and for those who travel upon them in the ordinary and accustomed modes. 25 AM Jure Highways. Section 426. Labor 1. The rights of locomotion, freedom of movement, to go where one pleases and to use the public streets in a way that does not interfere with the personal liberty of others are basic values implicit in the concept of ordered liberty, protected by the Due Process Clause of the 14th Amendment. Citations omitted. One may be on the streets even though he is there merely for exercise, recreation, walking, standing, talking, socializing, or any other purpose that does not interfere with other persons' rights.
So right here, you can see when they're like, oh, you're loitering, you're doing this, you're doing that. You have the right to do these things. You have the right.
Rights. Further, no right is more sacred, or is more carefully guarded, by the liberty assurance of the Due Process Clause than the right of every citizen to the possession and control of his own person, free from restraint or interference by the state. The makers of our Constitution conferred, as against the government, the right to be let alone, the most comprehensive of rights and the right most valued by civilized man. Union Pacific Railway Company vs. Botsford 141 U.S. 250, 11S, CT 1000, Olmsted vs. United States 277 U.S. 438, 48S, CT 564. Uninhibited movement is essential to freedom. Baker vs. Bindner, 274F, Sup. 658, 662 WD Kentucky 1967, see Aptheker vs. Secretary of State, 1964, 378 U.S. 500, 84S, CT 1659, 12L, ed. 2D 992, ID at 1254-55, brackets added. See Papachristou, Supra. Further, we recognize that defendant would distinguish pedestrians strolling and meeting on the sidewalk from persons operating motor vehicles on the streets, but we reject this argument. Motor vehicles are a lawful means of locomotion and plaintiff has the right to drive himself where he pleases, to go where he wants to go for whatever reason if he is otherwise obeying the law, including relevant traffic statutes and ordinances. Plaintiff has therefore asserted a valid liberty interest. Intrastate travel, as we understand that phrase, encompasses the right to migrate freely within a state. Lutz vs. City of York, Pennsylvania, 692 F. Sup. 457. It should be noted here that the court does not use the phrase drive a motor vehicle or operate a motor vehicle, both of which have very clear contextual meanings in commerce. The terms motor vehicle and drive are broad terms, and these terms should not be confined to a single definition unless strictly done so by a legislative body. See Huddy and DLLA Infra. The term travel is a broad term having two legally distinguishable meanings. One being the statutory definitions listed herein, which specifically clarify that commercial travel is accomplished when a person undertakes to deliver, using a public highway, that which has been purchased, and accepts a fee for such delivery. The other, being normal everyday use, as discussed above, by way of traveling public roads to connect oneself with the community. As the Eggert Court points out, traveling the highways is not based on the Commerce Clause. The right to travel is a right applicable to intrastate as well as interstate commerce. Inasmuch as the right to travel is not based on the Commerce Clause, it does not depend on the interstate nature of travel. Rights such as the right to travel, which involve personal liberty, are not dependent on state lines. Both travel within and between states is protected. Eggert et al. v. City of Seattle 81 WN2 D840, citing King v. New Rochelle Municipal Housing Authority, 314 F. Sup. 427, SDNY 1979, Carp v. Collins, 310 F. Sup. 627, DNJ 1970, see also Moan v. Erlinson 80 WN2 D755, Fraser v. Shelton 320 IL 253. This concept is further amplified by the American Jurisprudence Encyclopedia, 1st edition. Right which he has under his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee one may, therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected, not only in his person, but in his safe conduct. 11 A.M. Jure, 1st, Constitutional Law Section 329. And further. Personal liberty consists of the power of locomotion, of changing situations, of removing one's person to whatever place one's inclination may direct, without imprisonment or restraint unless by due process of law. Bouvier's Law Dictionary, 1914 edition, Black's Law Dictionary, 5th edition, Blackstone's Commentary 134, Hare, Constitution, page 777. Justice Tolman was concerned about the state prohibiting the citizen from the most sacred of his liberties, the right of movement, the right of moving one's self from place to place without threat of imprisonment, the right to use the public roads in the ordinary course of life. When the state allows the formation of a public corporation business, it may control its creation by establishing guidelines, statutes and charters for its operation. Companies that use the roads in the course of business do not use the roads in the ordinary course of life. There is a difference between a corporation and an individual. The United States Supreme Court has stated, "We are of the opinion that there is a clear distinction in this particular between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for examination on the suit of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way.
There it is.
His power
The Supreme Court, the highest law in the land other than God, said you have a right to carry on your private business in your own way. Right? Mother effing there. This is what they ruled on. This isn't hearsay or whatever else. They said, your private business, you have the right to do it. This is what the states are trying to deny you. That police officer trying to deny you. He's denying you your constitutional right as a private citizen to do private business. This is a federal lawsuit. And if we have to take it to the Supreme Court, we'll take it there, but we haven't even had to go past the federal court. Hell, we've been beating them in their own courts with this information because they don't want us to take it to the federal court or higher, because they will lose. But you have to do it the right way. And even if some cop steps on your rights, that's okay. You're going to sue him and the municipality. And each lawsuit that comes through is cheddar out of their pocket, and they're going to eventually start to tell everybody, hey, which is already happening, if those people are not speeding or endangering things, leave them alone. That is it. Let's go.
Power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business, or to open his doors to investigation, so far as it may tend to incriminate him. He owes no such duty to the state, since he receives nothing therefrom, beyond the protection of his life, liberty, and property. His rights are such as the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law, and in accordance with the Constitution. Among his rights are the refusal to incriminate himself, and the immunity of himself and his property from arrest or seizure except under warrant of law. He owes nothing to the public so long as he does not trespass upon their rights, further. Upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises, and holds them subject to the laws of the state and the limitations of its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that the state, having chartered a corporation to make use of certain franchises, could not in exercise of its sovereignty inquire how those franchises had been employed, and whether they had been abused, and demand the production of corporate books and papers for that purpose. Hale v. Hinkle 201 U.S. 43. Corporations engaged in mercantile equity fall under the purview of the state's admiralty jurisdiction, and the public at large must be protected from their activities, as they are engaged in business for profit. In order to reach a full understanding of the right versus privilege, it is important to know that courts have ruled consistently without ambiguity. No sacrifice exists. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda v. Arizona 384 U.S. 436, 86s, CT 1602. The claim and exercise of a constitutional right cannot be converted into a crime. Miller v. U.S. 230 F. 486. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. Sherrar v. Cullen 481 F. 946. Streets and highways are established and maintained for the purpose of travel and transportation by the public. Such travel may be for business or pleasure. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and the individual cannot be rightfully deprived. Further, even the legislature has no power to deny to a citizen the right to travel upon the highway and transport his property in the ordinary course of his business or pleasure, though this right may be regulated in accordance with the public interest and convenience. 25 a.m. Jure. First, Highways, Section 163. Chicago Motor Coach Company v. Chicago, 337 ill 200, 169 NE 22, Ligure v. Chicago 139 ill 436, 28 NE 934, Boone v. Clark 214 SW 607 Texas Civ Tap. The right of the citizen to travel upon the public highways and to transport his property thereon, either by horse-drawn carriage or by automobile, is not a mere privilege which a city can prohibit or permit at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. The right of the citizen to travel upon the public highways includes the right, in so doing, to use the ordinary and usual conveyances of the day, and under the existing modes of travel. Thompson v. Smith 155 VA 367, 154 SE 579. It is certain that a citizen has a right to travel upon the public highways by automobile, and the citizen cannot be rightfully deprived of his liberty. The courts have held that a citizen has the right to travel upon the public highways, but that he does not have the right to conduct business upon the highways.
There it is. So for those people, when I tell you as CDL drivers or whatever else, the American people are like, hey, look, anybody who's on our roads for profit, if you're making money on our roads, we need money from you. So that's why the CDL drivers, police officers, you cannot do this in your public capacity. In your private capacity, you can right to travel too. Let's go.
Highways. The ill-conceived notion that the right to use of the common roads is always and only a privilege comes from, firstly, the ever-threatening presence of the police, followed by ignorant fear-gotten gossip. The courts have stated it as follows. For while a citizen has the right to travel upon the public highways and to transport his property thereon, that right does not extend to the use of the highways either in whole or in part, as a place for private gain. For the latter purpose, no person has a vested right to use the highways of the state, but is a privilege or a license which the legislature may grant or withhold at its discretion. State v. Johnson 75 Mont 240, 243 p. 1073, Cummins v. Jones 79, Re 276, 155 p. 171, Packard v. Banton 264 U.S. 140, 44 s. CT 256, Hadfield v. London 98 Wash 657, 168 p. 516. Heretofore the court has held, and we think correctly, that while a citizen has the right to travel upon the public highways and to transport his property thereon, that right does not extend to the use of the highways either in whole or in part, as a place of business for private gain. Willis v. Buck 81 Mont 472, 263 p. 982. Barney v. Board of Railroad Com. 93 Mont 115, 17 p.2 d 82. The right of the citizen to travel upon the highway and to transport his property thereon, in the ordinary course of life and business, differs radically and obviously from that of one who makes the highway his place of business for private gain in the running of a stagecoach or omnibus. State v. City of Spokane 109 Wash 360, 186 p. 864. What is this right of the citizen which differs so radically and obviously from one who uses the highway as a place of business? The court, in noting a radical and obvious difference, went on to explain what the difference is. The former is the usual and ordinary right of the citizen, a common right to all, while the latter is special, unusual, and extraordinary. And this distinction, elementary and fundamental in character, is recognized by all the authorities. State v. City of Spokane Supra. Undoubtedly, the right of locomotion, the right to move from one place to another according to inclination, is an attribute of personal liberty, and the right, ordinarily, of free transit from or through the territory of any state is a right secured by the 14th Amendment and by other provisions of the Constitution.
Right there. The right of free transit. Free would be private, wouldn't it? It doesn't cost you anything whatsoever to go from here to there. But on the public side, the commercial side, with a registered vehicle, you have to pay. Pay for your plate, pay for a toll, pay to register, pay for your license, pay. Well, that seems to be like that's a problem because this goes against the Constitution. So how are they able to do this? Because people were tricked into believing they had to have a license and register their property to the state when there was no law. Don't mind me, I'm just trying to check through some sections here. All right. So probably what I'm going to do, oh, something by the Attorney General, is I may try to break this all up into its different sections, but we'll see. Let's see here. Okay. We are somewhere in here, so we'll start.
There exists considerable authority on the subject of the deprivation of the liberty of an individual using the roads in the ordinary course of life and business. However, it should be noted that extensive research has not turned up one case or authority acknowledging the state's power to convert the individual's right to travel upon the public roads into a privilege. See Miranda v. Arizona Supra. Therefore, it is concluded that the citizen does have a right to travel and transport his property upon the public highways and roads, and the exercise of this right is not a privilege. Driving is not traveling, absent express language to the contrary and proof of allegation. Notwithstanding the static eccentricities, no conviction may be lawfully sustained or upheld. Nullum simile est idem, things that are similar are not identical. Expressio unius est exclusio alterius, the expression of one thing is the exclusion of the other. No person shall be deprived of life, liberty, or property without due process of law. The courts at many levels have firmly established an absolute right to travel. The state, by applying commercial statutes to all who would use the highways, has deprived the common traveler of the right of liberty, without cause and without due process of law.
Facts.
The essential elements of due process of law are notice and the opportunity to defend. Simon v. Kraft 182 U.S. 427. Yet, not one individual has been given notice of the loss of the right to travel the roads and highways, let alone before signing the driver license application or the application for vehicle title. To defend against the potential loss of the right to travel, by automobile, on the highways, the traveler must be armed with the knowledge that there was an intentional concealment by the Department of Licensing. There should be no arbitrary deprivation of life or liberty. Barber v. Connolly 113 U.S. 27, Yickwa v. Hopkins 118 U.S. 356. The right to travel is part of the liberty of which a citizen cannot be deprived without due process of law under the Fifth Amendment. This right was emerging as early as the Magna Carta. Kent v. Dulles 357 U.S. 116, 1958. The right to travel is a part of the liberty of which the citizen cannot be deprived without due process of law under the Fifth Amendment. If that liberty is to be regulated, it must be pursuant to the lawmaking functions of the Congress. Freedom of movement across frontiers in either direction, and inside frontiers as well, was a part of our heritage. Travel abroad, like travel within the country, may be as close to the heart of the individual as the choice of what he eats, or wears, or reads. Freedom of movement is basic in our scheme of values. 62 CJS Municipal Corporations Section 148 et seq., citing Kent v. Dulles, Supra. Since the state alleges, and forcibly alludes, that one give up the right of traveling in order to exercise the privilege of driving, the statute regulation cannot stand under the police power, or due process, but which must be exposed as oppressive by misapplication and misrepresentation, to deprive the citizen of rights guaranteed by the United States Constitution and the state constitutions. Any claim that this statute is a taxing statute would be immediately open to severe constitutional objections. If it could be said that the state had the power to tax a right, this would enable the state to destroy rights guaranteed by the Constitution through the use of oppressive taxation. The question herein is one of the state taxing the right to travel by the ordinary modes of the day, and whether this is a legislative object of the state taxation. The views advanced herein are neither novel nor unsupported by authority. The question of taxing power of the states has been repeatedly considered by the Supreme Court. The right of the state to impede or embarrass the constitutional operation of the U.S. government or the rights which the citizen holds under it has been uniformly denied. McCulloch v. Maryland 17 U.S. 4 Wheat 316. The right to travel may not be restricted, regulated, or alienated. No state or court of any jurisdiction, neither any legislative body, not one in this country, has authority to require an individual to apply for a privilege.
Facts.
The state may have discretion to grant or withhold the business privilege. However, it is the sole discretion and proprietary interest of the individual to even reach the point of making application. The distinction can be simply stated as, an individual has a right to do that only which affects and benefits him, but no one has a right to do that which affects the community. The rule of travel is the same as the rule of standing. The rule of standing, simply stated, saving further elaboration, says a person may only sue on their own interest, and may not sue on the interest of the people at large. The distinction between a right versus a privilege to use the public roads is drawn upon the line of using the road as a place of business, and the various state courts have ruled as much. The U.S. courts equally held to this point. First, it is well-established law that the highways of the state are public property, and their primary and preferred use is for private purposes, and that their use for purposes of gain is special and extraordinary which, generally at least, the legislature may prohibit or condition as it sees fit. Stevenson v. Binford 287 U.S. 2. So what is a privilege to use the roads? The distinction has been drawn between traveling upon and transporting one's property upon the public roads, which is our right, and using the public roads as a place of business or a main instrumentality of business, which is a privilege. The roads are constructed and maintained at public expense, and no person therefore can insist that he has, or may acquire, a vested right to their use in carrying on a commercial business. Ex part Sterling 53 SW.2D 294. Barney v. Railroad Commissioners 17 P.2D 82. When the public highways are made the place of business, the state has a right to regulate their use in the interest of safety and convenience of the public as well as the preservation of the highways. Further, the state's right to regulate such use is based upon the nature of the business and the use of the highways in connection therewith. Thompson v. Smith, Supra. We know of no inherent right in one to use the highways for commercial purposes. The highways are primarily for the use of the public, and in the interest of the public, the state may prohibit or regulate the use of the highways for gain. Robertson v. Department of Public Works, Supra. Wholesale licensing is accomplished under the guise of regulation. The Department of Licensing never asks what the name of the business is, they automatically assumed the person is the business. This statement is indicative in and of the state's perseverance to ignore the limits placed upon governments by and through the several constitutions. Further discussion of this is found in public disclosure, herein. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. U.S. Constitution Amendment 9. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda v. Arizona 384 U.S. 436, 491. The legislature does not have the power to abrogate the citizen's right to travel upon the public roads, by passing legislation intimidating the citizen to waive his right and convert that right into a privilege. Furthermore, we have previously established that this privilege has been defined as applying only to those who are conducting business on the streets or operating for hire vehicles. The legislature has conspired, by legislative obfuscation, to deprive the citizen of his right to use the roads in the ordinary course of life and business, without affording the citizen the safeguard of due process of law. This has been accomplished under elusive powers of regulatory authority. In addition to the requirement that regulations governing the use of the highways must not be violative of constitutional guarantees, the prime essentials of such regulation are reasonableness, impartiality, and definiteness or certainty. 25 AM, jure. First, highways, section 260. Moreover, a distinction must be observed between the regulation of an activity which may be engaged in as a matter of right and one carried on by government sufferance of permission. Davis v. Massachusetts 167 U.S. 43, Packard v. Banton Supra. The only limitations found restricting the right of the state to condition the use of the public highways as a means of vehicular transportation for compensation are, 1. That the state must not exact of those it permits to use the highways for hauling for gain that they surrender any of their inherent U.S. constitutional rights as a condition precedent to obtaining permission for such use. Riley v. Lawson 143 So. 619, Stevenson v. Binford, Supra. We find it intolerable that one constitutional right should have to be surrendered in order to assert another. Simmons v. United States 390 U.S. 377. The promulgation of core terms, including, inter alia, the terms road, street, alley and highway, whether it be denominated a freeway, is and are cohesive. A road is defined generally as an open way or public passage for vehicles, persons, and animals, a track for travel or transportation to and for serving as a means of communication between two places usually having distinguishing names. Webster's Third New International Dictionary. In common parlance, therefore, a road is a thoroughfare intended to facilitate travel, including vehicular travel. Furthermore, that the state may under the police power regulate travel upon the public highways cannot be doubted. Silver v. Silver, 108 Con 371, 143a 240, aft, 280 U.S. 117, 50 S, CT 57, 74L, ed. 221. Above the court stated to facilitate travel, including vehicular travel. The court so stating, confirms that vehicular traffic is a separate and distinct activity from mere travel.
There it is.
It is further stated below, for the purposes of travel and...
Did you hear that? So the courts damn well know vehicular traffic. We have to look into the words. They don't mean what you think they mean. Vehicular. This is their word. And then the word traffic. This means commerce. Public. For profit. Is separate and distinct from mere travel.
And commerce. This conclusively solidifies that there are in fact two distinct and separate uses, one public business, the other personal private travel. The right of the public in a common highway is paramount and controlling. This right extends to the entire territory within its limits, and an obstruction placed upon any part of it constitutes a public nuisance. The law applied to motor vehicles. Babbitt Section 34, at 104 citing Morton v. Moore 81 Mass, 573, citing Commonwealth. 5 King 13 Met. 115. The title of the public in the highway is that of an easement for passage and repassage, that is to say, it is a right to use for purposes of travel. The right of no one is exclusive, but is to be exercised with regard to the equal right of everyone else. It is a right which each enjoys in common with all his fellow citizens. The subject is clearly summarized in the Pennsylvania motor vehicle case of Radnor Township v. Bell, 27 Pascals, Super. CT 1, 1904, where the court say. Huddy on Automobiles 6th ed., citing Jenkins v. Goodall 183 Ill App 633. Huddy Automobile Law 9th ed., Definition and Distinctions Section 3. A mule team, a golf ball, or a nail may be driven. These are generic idioms of driving. Legally speaking, though, to drive is a more specific and intentional act as discussed in licensing later on. The same is true for motor vehicle, which generically describes any of several genera of motorized vehicle, which are self-propelled by an internal combustion engine or an electric motor, or as now, in the 21st century, hydrogen engines. HUD Automobile Law 9th ed., Definitions and Distinctions Section 1. HUD Automobile Law 9th ed., Definitions and Distinctions Section 7, citing Chamberlain's Modern Law of Evidence. HUD Automobile Law 9th ed., Definition and Distinctions Section 7, see also City of Chicago v. Gall below. Let's rewind briefly. This is what the Hadfield Court said of highway use. The former is a common right. As to the former, the ordinary right of the citizen to use the streets in the usual way, the legislative power is confined to regulation. The latter is an extraordinary use. As to the latter, the use of the streets is a place of business, for private gain, it is plenary and extends even to absolute prohibition. Since the use of the streets by a common carrier in the prosecution of its business as such is not a right but a mere license of privilege. Because the state may absolutely prohibit the use of the streets as a place for the prosecution of a private business for gain. Caution should be taken when using the term private. When used by the public state, the term private has a business connotation, because public business itself can be either common or private, as confidential between two parties. This writer recommends the term personal private in order to distinguish and eliminate any confusion that may arise. The Washington State Supreme Court has long-standing declared the difference of uses of automobiles not inconsistent with the breadth of this document. When taxi operators had their licenses suspended, they appealed claiming loss of liberty. The word particular in this exemplar ruling identifies a factual distinction between personal conduct and commerce, and even suggests that one may use a company vehicle for personal use when not commercially engaged. The court said this: the defendants are being prohibited from using a particular mode of travel in a particular way. State v. Sheffel 82 WN 2D 872. The evident purpose of the ordinance was to regulate and supervise the business of public carriers of passengers upon the streets of the city for the convenience and safety of the public. The license is required when one engages in that business and not when he used a vehicle for his own accommodation. In other words, the ordinance does not purport to regulate or supervise the mechanism of vehicles that are allowed to use the streets. It is only the business of public conveyance of vehicles of some kind that is subject to the supervision of the city. State v. Dunkley 76 NH 439, 84 ATL 40. City of Chicago v. Gall 195 Il App 41. See also HUD on Automobiles 6th ed., Section 145. HUD on Automobiles 6th ed., Section 149. In the early 20th century, the state of Washington has ruled that personal and private use of one's personal automobile is perfectly legal and lawful.
Boom. Boom. We've been saying this. Even more proof. Time and time again. Time and time again. They already rule that there is a personal and private use. It's a business use. But they're saying here, personal and private use of one's personal automobile. Notice how they didn't say motor vehicle. Motor vehicle is a commercial term. They're using these words specifically. This is the state. They ruled. Probably, I don't know if this is on just the state level, the court, district. But the state of Washington ruled it is legal and lawful. That's why I've been telling you. These words mean different things. Legal means on the corporate level, so the state of Washington, they're saying it's legal for you to do that. Lawful is the Constitution. They're saying both of these, how should we say, I guess, areas of jurisdiction agree as long as you're doing it right. So what are cops doing? What are judges doing? If they are corrupt and stupid, then they are unwittingly, unknowingly defying you of your legal right and your lawful right when done properly with your personal automobile. Who can call it this? Whoever owns it. But if you register it and don't pull it out properly, you don't close your accounts, then they're going to consider it commercial, public, to be administered.
Lawful. It is only under the auspice of a violation of commercial licensing statute policies that it could be said one has committed a traffic crime. The state would have to act in bad faith to rule personal use of public highways lawful and then with surreptitiously spurious intent, dare to bring a criminal violation of a policy which offers no jurisdiction, no redress, and no authority over lawful conduct. Ago 61 to 62 number 46 ___________________ edited for space and content. Outside the confines of Chapter 81.80 RCW, but of prime importance and significance to our consideration of this matter is RCW 81.04.460 providing. The Commission shall enforce the provisions of this title and all other acts affecting public service companies, the enforcement of which is not specifically vested in some other officer or tribunal. Thus, addressing ourselves solely to that portion of your question which relates to driver qualifications, we conclude that the Public Service Commission has the authority to both adopt and enforce rules and regulations governing driver qualifications with respect to auto transportation companies and motor freight carriers. By this, we do not mean to imply that such authority includes the power to prescribe conditions precedent to the issuance of a motor vehicle operator's license. The general supervision and control of the issuance of vehicle operators' licenses is specifically vested in the Director of Licenses. RCW 46.20.010. However, the Commission may prescribe safety regulations over and above those prerequisite to the issuance of a driver's license with respect to the drivers of auto transportation companies and motor freight carriers. Insofar as your question relates to the authority of the Commission to adopt and enforce rules and regulations governing safety of equipment, a final conclusion at this juncture would be premature without first considering certain provisions of Title 46 RCW. Section 46.08.010, Chapter 12, Laws of 1961, provides in material part. The provisions of this title relating to the Certificate of Ownership, Certificate of License Registration, Vehicle License Plates and Vehicle Operator's License shall be exclusive. In this respect, it is worthy of note that although several provisions of Chapter 81.68 RCW and Chapter 81.80 RCW have been amended at various times since the original enactment and amendment of RCW 46.37.005, the legislature has never seen fit to amend in any way the particular provisions of RCW 81.68.030 and RCW 81.80.130 which grant the Public Service Commission the authority to regulate the safety of operations of auto transportation companies and motor freight carriers respectively. Under these circumstances, we do not feel it can be said that there is a manifest intent upon the part of the legislature to effect a repeal by implication. Under the maxim expressio unius est exclusio alterius, it is the uniform rule that the express mention of one thing in a statute implies the exclusion of all others. State ex rel. Port of Seattle v. Department of Public Service, 1 WN, 2D, 102, 95 p. 2D, 1007, 1939. Provisions relating to the same subject matter embodied in different statutes should be harmonized so as to maintain the integrity of both statutes whenever possible. State ex rel. Showmaker v. Superior Court, 193 Washington 465, 76 p. 2D, 306, 1938. Furthermore, as previously noted, the authority to regulate granted by RCW 46.37.005 supra, and the other provisions of Chapter 46.37 RCW apply to motor vehicles generally. It is well established that a general statute does not repeal a special statute on the same subject, unless the intent to repeal is manifest, and such an intent cannot be implied unless the two acts cannot stand together and effect be given to both. State v. Whitney, 66 Washington 473, 120 Pac. 116, 1912, and cases cited therein. In determining whether any particular rule or regulation of the Public Service Commission is in conflict with those of the State Commission on Equipment or those set forth in Chapter 46.37 RCW, the test is whether the former permits or licenses that which the latter forbids or prohibits, and vice versa. Bellingham v. Scampra, 157 Washington December 1, 1960, 57 WN.2d 106. There yet remains for consideration the question of the Public Service Commission's authority to enforce those rules and regulations which it properly adopts. Its authority in this respect is sufficiently prescribed in that portion of RCW 81.04.460, supra, providing the Commission shall enforce the provisions of this title and all other acts affecting public service companies, the enforcement of which is not specifically vested in some other officer or tribunal. John J. O'Connell, Attorney General. Dwayne S. Stuckey, Assistant Attorney General. Police
All right, all right, all right. What do we have here now? That last part was brought to you by the attorney generals of those particular states. They know about this. The government knows about this. Government knows far more about your rights than you do, but there's no law that says they have to educate you in it. If you're private, you need to educate yourself. You need to be prepared to stand on your square, as they say, with your information. You have the right to exercise these freedoms, liberties, and rights, but you may have to defend them in court, state and federal level. If you feel so moved to do so. All right, guys, that's it. I will be doing another video on the remainder. I'm going to break it up into sections because I don't think anybody really wants like a 6-hour video. So this is part 1. Part 2 should be popping up theoretically, hopefully in one of these squares. I'll try to link it that way. And I will talk to you guys later. Let's go take a break, get a little sunshine, move the feet to the beat. And I'll see you guys later.